And we continue to track what's happening inside the courtroom in the Arvind Kejriwal case. Right now, heated arguments in High Court are taking place after the Delhi High Court halted release of Arvind Kejriwal. Well, the stay came after ED moved Delhi High Court, saying that they were not given enough time to make arguments. ED also said that we have not received order copy of bail yet. So heated arguments are underway in Delhi High Court when the Aam Aadmi Party was on the other hand celebrating the release of its chief Arvind Kejriwal. We also have Sunil Prabhu joining us on the broadcast. Sunil, can you take us through what's happening inside the courtroom?
Well, as we speak, we are still waiting for the file and for the court to hear this entire matter. As you pointed out, this was the ED moved the special court. Delhi High Court, after the special court had given the bail to Mr. Arvind Kejriwal, the Chief Minister of Delhi. And both of them, Mr. Arvind Kejriwal is waiting for the release order, as well as, of course, the Enforcement Directorate is waiting for the judgment and the order so that they can challenge it in the Delhi High Court. So the Delhi High Court has paused the letting off of Mr. Arvind Kejriwal until it hears this matter. And we are still waiting for that file to be submitted by the Enforcement Directorate before the High Court, where they'll hear this entire case and then take a decision, or one way or the other, of whether they should give, agree to the Enforcement Directorate's plea or allow Mr. Arvind Kejriwal to be released.
Right. We also have Aishwarya joining us on the broadcast. Aishwarya, if we speak about the politics, okay, before going to, Aishwarya, Sunil, if you can tell us that while they're waiting for the copy, the political showdown has also begun. Saurabh Bhardwaj is saying that the law has no meaning for the central government. When the order did not come, which order did the ED challenge in the High Court?
Well, the politics has always been there, right from day one, ever since the excise scam has taken place. It's been a war of words between the Aam Aadmi Party and the BJP. And this has been a continuous saga for the last 3 years now. And it's in this backdrop we will have to wait and see how things play out. It's definitely, ahead of the state elections in Delhi, which is due next year. It's going to be definitely a big controversy that will continue. So definitely, Saurabh Bhardwaj, who's a minister, saying about saying the plea. So you will definitely fight. You have this war of words and these the political bashing between both political parties, the Aam Aadmi Party and the BJP in the city of Delhi.
Sure. Let me also bring in. Thank you, Sunil. We also have Aishwarya joining us. Aishwarya, if we can talk about the politics over the entire case. Sanjay Singh, Saurabh Bhardwaj, all are pointing out that this is just illegal. How the ED could have moved the Delhi High Court.
Well, certainly it is on one side the Enforcement Directorate, which last night only planned that they will move Delhi High Court to have a stay on the release of Arvind Kejriwal after the order got released from the Delhi South Avenue Court. And the planning was made last night only, and today as the vacation bench sat down at the Delhi High Court, it was the Enforcement Directorate which reached out to them and asked for the stay. They clearly had stated that because the order copy was not out till morning and it has not been uploaded, they has no clue what is in the order, and therefore the reason perhaps they urged the vacation bench of the Delhi High Court that until the entire argument did not finish over here in Delhi High Court, the release should be stayed for that period of time, and Delhi High Court clearly admitted it. On the other side, remember, it was Aam Aadmi Party who had already planned throughout the day what needs to be done when Arvind Kejriwal will walk out from the Tihar jail. It was already in line that Aam Aadmi Party, along with several leaders of the political party, as well as Arvind Kejriwal, will go to Rajghat, to which the permission according to Aam Aadmi Party had not been granted. It was Saurabh Bhardwaj who alleged that what kind of Tana-Shahi government is this when they are not allowing to go to Rajghat, and also the central government is opposing when the order has already not reached out to them. So it's what order they are challenging in the High Court. So clearly it was a war of words that turned out between the Aam Aadmi Party and the the Bharatiya Janata Party, as they stated that the law is taking its own course. It is the legal right of the Enforcement Directorate to reach out to the higher court to put on stay. Remember, in the entire argument that that went on yesterday for several hours, it was stated by the Enforcement Directorate before the House Revenue Court that the investigation, it has a very crucial juncture, and at this point of time when Arvind Kejriwal, who according to them is a key accused in this entire case, who directly asked for a bribe of 100 crore rupees, will be granted bail, then it would be a setback for them and it can hamper many evidences. Certainly it was the argument on the behalf of Arvind Kejriwal that and his counsel stated in front of the court that there has been no fresh evidences that had been found out since the time he is inside the jail, and therefore the reason all of these arguments on the part of Enforcement Directorate is not valid, and this for the very first time Arvind Kejriwal applied for a regular bail fee in the Delhi's Rouse Avenue Court, to which he got relief. But certainly a setback from the Delhi High Court when Enforcement Directorate reached challenging this order, and we've been told that now when the argument will finish, what comes out, whether Delhi High Court gives relief to Arvind Kejriwal and or he will come or he will be behind bars, is something that remains to be seen. But an interesting turn of events that took place soon after the Enforcement Directorate reached to the Delhi High Court.
Right. Thank you so much, Aishwarya, for detailing the political outcome of this order, and for the legal part of it. I am being joined by two guests, Khushbu Jain, who is an advocate in Supreme Court. We also have Ashutosh Srivastava joining us as an advocate in Supreme Court. Khushbu, if I can come to you first, how should this entire matter of Kejriwal's bail be seen?
See, it should be seen as any other accused who's there in the court and who's been implicated or is under trial when it comes to offences under PMLA. There should not be any difference, and here if a difference has to be, it should be put in more of an importance, because a sitting chief minister of a country, if it's found for such a crime, there has to be a fair trial, there has to be a fair ground when it comes to granting of bail. The procedure should be followed. One should not be given an extra advantage or disadvantage for that matter, or any sort, when it comes to enforcement of law, when it comes to investigation, and when it comes to granting of bail from the court. So I think that's where I stand. And if you look into PMLA has a very strict the statute. If I have to quote section 45(1) of the statute, that says that the no accused shall be released on bail unless the court is satisfied that there is a reasonable ground for believing that he is not guilty of such an offence, and that he is not likely to commit any offence while on bail. This is one. The second, that a person who is accused will not tamper with the investigation, tamper with the evidences which can be impediment to the investigation. So if you look into all these criteria, I think the fair hearing, the aspect of all these criteria, if are met and are being taken care of, everybody has got a aspect where they can apply for a bail. So it should not be treated as any other matter. And that's where I think I would take up the matter, that so that it showcases that or it believes, or it brings in that aspect that we believe in our judiciary, we believe in our enforcement agencies, that there is no differentiation if somebody is with the power or somebody is without the power. That's my personal opinion.
Right. Mr. Ashutosh, if I can come to you, I want to ask you, is the ED not right in challenging Kejriwal's bail, which was granted by the lower court?
As my learned friend also explained, now see section 45 of the PMLA, Prevention of Money Laundering Act, it has got twin conditions. One is that while granting the bail, the court has to give the opportunity to the prosecution to oppose the bail with all the grounds what they can put across. And secondly, that the court should be satisfied that the accused has not committed or is guilty of committing that particular crime, and that he would not commit the same crime in future. So here the ED, which has filed an appeal before the Delhi High Court, making a statement that they were not given appropriate opportunity to oppose the bail while the bail was granted by the trial court, and hence they have moved to Delhi High Court. See, there is a provision in Criminal Procedure Code that is section 439 and subsection 2, which gives the powers to the High Court to cancel a bail on certain grounds or conditions if they feel that the bail has been granted by not considering the appropriate merits of the case. So here it is not that the bail has been cancelled by the High Court. It is just on on hearing, and yes, it has stayed the bail granted by the trial court for a obvious reason that if it does not stay, then the petition or the appeal filed by the ED becomes infructuous, because it will have no value once the accused has come out of the jail. So, the High Court has to consider whether the bail granted by the trial court is to be confirmed. It has to be confirmed, or it has to be reversed. So that is what the hearing is about today, and I'm sure Delhi High Court will look into the minute details on the grounds on which the trial court has granted the bail. If it finds it to be appropriate and correct, and it feels that there will not be any tampering of evidence, or there will not be any influence of witnesses once he is released from the jail, then obviously it can confirm the bail. However, if it has some contrary view, then it can pass such contrary orders as well.
Right, and Ashutosh, just how you were talking about the bail order, we also have access to the conditions on which Arvind Kejriwal was granted bail, and it states, on the first, that he shall furnish a bail bond in the sum of rupees 1 lakh with once, surety of the like amount of the satisfaction. Then he should not leave the country without seeking permission of the court. The third statement, the third condition that was on the bail which was given was that he shall make himself available in respect of the investigation before the investigating agency or before the court as the case may be. The fourth condition, that as per the bail order, it states that he shall not try to tamper with any evidence pertaining to the present case. And while we highlight this point that he shall not try to tamper with any evidence pertaining to the present case, Ashutosh, as you were just talking about, he's a very influential personality. The ED is also opposing the bail on this charge.
Yes, see, the ED has, any investigating agency has the constitutional right. If they want to oppose the bail, they can go to the higher court. Now the higher court has to see that the grounds on which this particular investigating agency has come for cancellation or challenging the bail granted by the trial court or any court below. So in that case, the court in which the appeal is pending has to look, minutely and in a very sensible manner whether this bail which has been granted should continue or not to continue. The conditions of bail, what you mentioned now, are the general conditions which are generally given by any trial court or any court which grants bail, because the main purpose of releasing an accused is that the investigation should not be tampered. And there should not be any tampering of the further witnesses, documentary evidences or anything. So here in this case, the ED has to, satisfy the court why the bail should be cancelled. Unless and until it satisfies the court in appeal that what are the grounds on which the bail should be cancelled, it will be difficult for the court to cancel the bail just like that. However, if they come up with strong grounds for the cancellation of bail, if they have something to state that why, if he is released on bail, can tamper with the evidences, how it can affect the investigation, how it will not lead to a proper conclusion of the trial. So all these things will matter, because I think earlier when the summons were issued, he had not attended, so that those issues will also come up. That if he is released, whether he will attend the trial on all the dates given by the trial court or not. Because it is not only him, because there are many others who are also having role in this particular case, and it is pertaining to the public at large. So all these aspects the court has to look into and has to decide the appeal on the merits on which the ED has filed this appeal before the High Court.
Right, Ashutosh, and if I'm not wrong, then Arvind Kejriwal skipped at least 9 summons, giving excuses like he's on a meditation spree and others. Khushbu, if I can bring you in, the kind of charges and the allegations that Arvind Kejriwal faces as per the ED, he's the kingpin of the Liquorgate, the alleged excise policy case. He's also being said that he transferred the money and diverted the funds for Goa elections. then what are the, is the ED's case against Kejriwal a waterproof case?
So if I have to sum it up, the claim, the aspect when it comes to what are the aspects which are against, or what ED claims is the aspect of secured inhabited access, undue favors, attained stakes in established wholesale businesses, multiple retail zones, paid rupees 100 crore to the leaders in return. These are all aspects which are under consideration, and if this is the aspect, if this has been proved, but we are talking about the trial aspect. Here when we are talking about bail, these are two separate things. Trial can continue, trial can go on, but one can always be granted bail if, again, those 4 conditions are be taken care of, that he is not a flight risk, he is not going to disappear from the country, he is not going to be impediment in the investigation, he will continuously cooperate with the investigating agency, and he will not tamper with the evidence. I think that's where the enforcement agencies are a little doubtful, and all of us are also considering the aspect that somebody with the powerful post, he's still sitting at that powerful post, he has those favors which he can still ask. So that's where I think if the question arises that whether there would be any kind of tempering of evidences or impediment to the investigation that will come up if he is granted bail or if he is out there and sitting at his position. So that's something which has to be looked into, because offences also, if you look into those offences, are with respect to utilizing of the power and taking favors. That's where I think the whole gameplay will come, and these would be the conditions that can be discussed during the bail hearing, that would be discussed right away. Stay was granted purely on the aspect that I was not being heard properly or given the chance, and that's everybody has it. Even Kejriwal would have got the chance to appeal if his bail would have been rejected.
Yeah, right.
Everybody has it.
Yeah, thank you so much Khushbu and Ashutosh Srivastava for joining us and explaining in detail what the legal procedure will be. We also have Aishwarya joining us on the bail order conditions that we have accessed. Yes, Aishwarya.
Well, certainly the bail order has been accessed by NDTV now, and there were, remember, 2 long days of argument that took place at the Delhi's Rouse Avenue court, in which it was stated by Arvind Kejriwal's counsel that the statements of the, and I'll share a few highlights from this order copy, which had put out some important remarks of what had been stated by the counsels of Arvind Kejriwal during these 2 long days. It was very importantly stated by Abhishek Manu Singhvi and Vikram Chaudhary, who appeared for Arvind Kejriwal during these arguments. It was stated by Arvind Kejriwal's counsel that the statements of the respective co-accused, namely Raghav Manguta, Bhuchi Babu, Abhishek Bonapalli, Sarath Chandra Reddy and Vijay Nair, on different dates, nothing incriminating was alleged against the applicant and accused, and some of these co-accused have been granted regular bail in the CBI matter as well. It was also stated by Arvind Kejriwal's counsel that the applicant received a summons under section 160 of the CRPC, in response to which the applicant was had presented himself before the CBI court, and never a day that he had refused to attend these court proceedings whenever he was summoned. It was also contended by Arvind Kejriwal during these arguments that the co-accused P. Chandra Reddy and Manguta Reddy, father of co-accused Raghav Manguta, recorded further statements which are contrary to their earlier statements that do not relate any offence under the section 3 of the PMLA Act. And these 2 days of the arguments, to which Enforcement Directorate clearly had stated that Arvind Kejriwal had been accused. He had been the Chief Minister of Government of Delhi and very high influential person, having potential to tamper with the evidences and influence the witnesses as well. It was also stated by the Enforcement Directorate that further investigation is going to trace out of the proceeds of crimes and role of various persons if the applicants are enlarged in a bail. Remember, it was stated by Enforcement Directorate that they have the Hawala operator statement, the WhatsApp chat between Mr. Chanpreet Singh, who was in charge of the Aam Aadmi Party Goa elections, and he took bribe of almost 45 crore of the cash. Of course, the bail condition.
And Aishwarya, we will be keeping a close track, and all eyes will be on Delhi High Court when the hearing will begin. But viewers, slipping into a very short break, don't go anywhere. Keep watching NDTV, because right after the break, we will tell you what's happening in the NEET showdown.